Good afternoon, everybody, and thank you for joining us for another segment in Conn Carey's 2019 OSHA webinar series. Today's program is about Cal-OSHA, an update on some recently changed rules, enforcement data and trends, and some things to look out for in the future. The first voiceless or faceless voice that you're hearing today is Eric Conn. I'm the chair of Conn Carey's OSHA practice. I'm based out of Washington, D.C., far from the Golden State there in California, where many of you are joining us from today. But I'm very pleased to be joined today by two of my colleagues. My partner, Andrew Sommer, who heads our California offices based there in San Francisco, and really heads our Cal-OSHA practice, as well as our California labor and employment practice, as well as our associate, Megan Shockhead, who joined the firm a little over a year ago. Is joining us to help present on Cal-OSHA issues today, and she practices in the field of Cal-OSHA and California labor and employment as well. We've got our bio slides here in the program, but I won't bore you with all that. You can check us out later if you don't already know us, and I do recognize a lot of the names as registrants here today, so hopefully you do know us well. But if not, there's more information about us here, but I'm sure you've dialed in today to hear about Cal-OSHA and not about Conn Carey, so we'll jump right in. You can see we've got a chock-full agenda today. It was actually pretty interesting that really in the last 2 or 3 days there were some interesting developments on the Cal-OSHA front. I think they knew that we were about to put this program on, and so they wanted to give us some really hot-breaking Cal-OSHA news to report on. So we're going to be covering some of that today and here, among these topics. We're going to talk a little bit first about Cal-OSHA enforcement data and trends, some enforcement data in terms of what standards are being cited, numbers of inspections, things like that, as well as some new either policy or soft policy issues that we've discovered anecdotally in our practice with Cal-OSHA throughout the last year or so. Also, we'll report on a fairly new and breaking development, a piece of legislation that's moving through the process in California called the California Environmental Public Health and Workers Defense Act of 2019, a way for California to stay as stringent an enforcement agency as they would like to, even as OSHA and the Federal Environmental Protection Agency may be moving a different direction. We'll also talk a little bit about Cal-OSHA's repeat violation rule. This is something we covered last year as a brand new rule last year. We'll talk a little bit about what we're seeing in that regard and how this can impact employers in California going forward. And then we'll give you the latest update on California's adopting the OSHA electronic record keeping, electronic data submission of injury and illness data, as well as other record keeping developments in the state. We'll also then be talking about the workplace violence prevention rule. We've talked about this in the last year or so during our annual Cal-OSHA update about the new rule in the healthcare space. Well, Cal-OSHA now is moving to take that rule from just the healthcare industry into all of general industry. So we'll talk about what's going on in that rulemaking and who may be affected by that. And then give you an update on the indoor heat illness prevention rule, again, where Cal-OSHA has historically, in the recent past, implemented a heat illness rule for outdoor workplaces. They're now moving to expand those requirements into other workplaces, and we'll talk about where they are in that process and what that could mean. And then finally, the latest rulemaking effort by Cal-OSHA this is an emergency rulemaking setting for protection from wildfire smoke. So we'll get into all of those subjects in more detail, and we'll start off with my partner Andrew Sommer talking about some Cal-OSHA enforcement trends.
Thank you, Eric. I wanted to address at the outset some really key enforcement trends in California. For those of you that operate outside of California, you might see some novel trends and developments here within the state. And the first issue that I wanted to discuss was the different standards that are most frequently cited under Cal-OSHA. And these are things that we have learned both through statistics and anecdotally through defending against these citations is that the standards that typically most come up in citations and ones that you have to be real careful about as an employer involve primarily citations under the Injury and Illness Prevention Program. This IIPP is the state equivalent of the General Duty Clause, and it's cited all over the place in various different ways where there's not another standard directly on point. So it typically comes up where there's a failure to have a written injury and illness prevention program, and also as well when there's a failure to train employees on workplace safety issues, a failure to conduct accident investigations, a failure to conduct hazard assessments. And there's also a number of citations at quite a high frequency of overheat illness prevention. And when Cal OSHA comes out to your workplace, the first thing they ask you for typically is your injury and illness prevention program document as well as your heat illness prevention document as applicable. So we see those two standards cited quite frequently. There's also a standard for reporting serious injuries and workplace fatalities, and that's under Section 342. And that's frequently cited. There's also a hazard communication standard that comes up quite often involving an employer's obligation to list hazardous chemicals in the workplace. And some other standards that come up are lockout tagout, involving the cleaning, repairing, or servicing of energized equipment and the measures that need to be in place in doing so. Also requirements over respiratory protection, portable ladders, which typically comes up, the citation over the failure to train on specific topics that are listed under the regulation. Also, there are frequent citations over a failure to have a permit to operate air tanks and a failure to undergo certain procedures for identifying and inspecting portable fire extinguishers. So,
Andrew, if I could make one point that I think is kind of interesting, but I'm a big OSHA nerd, is that this list is pretty similar to Fed OSHA's list of most frequently cited standards. The biggest differences in the two lists, as you might imagine, are the standards that are unique only to California. You know, the I2P2 rule, the heat illness rule, and then Cal OSHA's nuances on reporting workplace fatalities and hospitalizations and serious injuries. Those are unique and special to Cal OSHA, so they couldn't be on Fed OSHA's list, but hazard communication, lockout, tagout, although not just portable ladders, but fall hazards generally are always high on Fed OSHA's lists. Respiratory protection also makes the top 10 in Fed OSHA's list. So it's interesting to see that there is overlap between Fed OSHA and Cal OSHA, and where there is divergence, it's in those areas where California, also the permits to operate air tanks is something that Fed OSHA just doesn't have a hand in, but Cal OSHA does. Where there's divergence, it's because Cal OSHA has a specific standard, and they're citing them with frequency. I just think that's interesting to note.
And another area where there is divergence is regarding the enforcement data. The data that we do have available from Fed OSHA is remarkably different than Cal OSHA to the extent that there's a higher percentage of citations issued per inspection by the regulatory agency that's here in California. And so we were able to obtain some data on Cal OSHA inspections, and they're quite remarkable in that for the 2018 timeframe, that's only a quarter. But we do have full years of data for the years 2014 to 2017. And what we see is that the number of businesses that have been inspected has increased per year from 13,000 to 15,000. That's a pretty significant jump. And these investigations concern both on-site inspections as well as letter requests that you may receive short of an actual inspection. And the data is also significant in showing a higher number of violations overall over the preceding years. So from 2014, or starting in 2014, we had 16,000 violations, and then in 2017 we see 20,000 violations. We also see a greater number of serious violations of the total number of violations that are assessed. So the serious violations presently, or at least as of 2017, were 4,780, and then back in 2014 we had 2,944. So that's a really significant increase. And so as you can see in the percentages at the bottom of the table, we go all the way from 18% up to 24% in the percentage of serious violations comprising the total violations that are assessed. So what does this all mean? I mean, right now there's a shortage of compliance officers at Cal OSHA. There's a number of vacancies. And perhaps once they staff the office at full capacity, we'll see even greater enforcement. But what this does mean presently is that you're more likely to be inspected, and that where you are inspected, you're more likely to be cited, at least in some form, and that citation could very well include a serious violation.
And as another frame of reference there, that data from 2014 to 2017 from the Fed OSHA side, we've seen about 6,000 fewer inspections conducted in 2017 than in 2014, and a greater number fewer total violations issued in that same period of time. So where Cal OSHA seems to be ramping up enforcement activity, Fed OSHA seems to be reducing the scale of its enforcement reach.
And I was going to add that this data is consistent with what I have been seeing in my practice as a Cal OSHA defense attorney. I'm seeing many more inspections and many more citations that are issued when there are inspections. But I did want to address one development, and this is what we've learned anecdotally from Cal OSHA, is there was a time when there was more freewheeling authority of the district manager, who is the one who runs the local Cal OSHA enforcement office, and that person would have pretty broad discretion in agreeing to settlements of citations after they issued, whether it be amending a citation or withdrawing the citation altogether. Now what we've learned is that there is an internal requirement for approval from the Assistant Chief Counsel of the division. And there has been that process in place for about the last year. And typically where this comes up is if there's a serious accident-related violation. We have seen for quite some time that that's a matter that will need to go up through the ranks, and for any resolution of that item to be approved by the Assistant Chief Counsel. That also applies to heat illness violations, and there is some discussion about serious violations that might not be accident-related, where under certain circumstances they might require approval from the Assistant Chief Counsel to be withdrawn or modified. So what does that mean? It really means that there's been long delays in resolving Cal OSHA cases that fall under these categories, and it's requiring a significant period of time to go up through the Cal OSHA office to obtain approval. And typically you need approval if you have to develop a proposal with the district manager. When the district manager signs off, then there'll be the channels that will be followed to obtain ultimate approval. So it is creating a bureaucratic backlog for sure, and that's what we've been finding. But I wanted to transition over to this bill that has just advanced through the California Senate, and it's called the California Environmental Public Health and Workers Defense Act of 2019. It's quite significant. It's made it through various different Senate bills in the Senate committees, within the state, but has not yet been approved. It's been making very steady progress, and what's really unique about this development is its broad breadth, in that it will potentially have an impact on safety regulations in a number of different capacities. And what it really reflects is the desire of the state to register its disagreement with the Trump administration whenever it can. And this law essentially, or the bill that's been proposed, will essentially adopt the California safety and health regulations that were in effect as President Obama was leaving office, to the extent that OSHA opts to roll back any of the regulations that were in effect at the time at the end of the Obama administration. And so under the OSHA plan, OSHA is authorized or has the authority to adopt regulations that are more protective of workers on safety and health issues, but it has to at least be as stringent as the federal standards. And as we know, there's many instances where California is more aggressive on the health and safety regulatory front. And so the desire of the California legislature here is to maintain the California's stronger workplace safety standards. And so there has been a perception in the state that where the federal and state laws are overlapping, that if the federal protections slip, then so do California's. And so to address that perception at least, they've introduced Senate Bill 1 to revert back to the baseline regulatory standards that at least were adopted at the federal level at the end of the Obama administration. And so there are a number of areas where OSHA has scaled back, and there's the Volks rule, there is the FAR contractor blacklisting rule. There has been record-keeping issues, E-Recordkeeping specifically, and the stated desire under this new proposed law is to revert back to the Obama rule. Now, there's a number of different mechanisms that have been put in place, and one issue is whether this is even necessary, because California does have its own authority to develop more employee protective workplace safety rules. But what they've essentially put in place is a mechanism, and they're requiring the OSHA Standards Board to assess any proposed changes or final changes to the federal standards. And once that assessment has been made, there has to be a quarterly publication of the list of changes at the federal level. And then the board, the standards board in California, must consider whether to adopt the federal standard in effect as of January 1st, 2017. And if it does so, it can go through this expedited rulemaking process that doesn't require the formal administrative rulemaking process. And then ultimately the board may adopt this new rule, or the rule in effect federally as of January 1, 2017, the baseline rule, and that can be done either by emergency regulation or through a regulatory amendment. And now I'm going to turn it over to Eric to discuss repeat violations.
Thanks, Andrew. And there are some comments there about this program getting political. We're not getting political. We're just reporting what California is doing. Whether we agree with it, I think the sense is we don't think it's necessary because California does have its own independent legislative and rulemaking authority, but this is something that California is doing that impacts OSHA and the California environmental agencies. So we want to make sure that you're aware of it and that you're able to adjust as necessary. So focusing now on OSHA's repeat violation rule, this is another area where California has adopted based on what's been going on in the OSHA ranks. Historically, within OSHA, the only way for an employer to be cited for a repeat violation was for a substantially similar violation to occur within 3 years in a very narrow specific location. For fixed establishments, meaning factories, terminals, stores where there is a specific establishment, a specific location, at a specific address, a OSHA repeat violation could only issue for another violation that occurred at that particular establishment, at that particular address, which made it for employers that have locations up and down the state or all across the country a narrow rule where you could only be cited at that one specific same location. And the same was generally true for employers that operated more loosely than a single address type of location. So if you were in construction, if you've got mobile crews, where citations were related to work that might one day be at this particular construction site and then at another where you're no longer at that site anymore, the repeat violation could only issue within the same Cal-OSHA region if it was issued within a workplace under the jurisdiction of the same district office. And so for that reason, repeat violations were unusually rare in Cal-OSHA. The rule also, as I said, required a 3-year look back. So the same violation, and that was the language in the old Cal-OSHA repeat rule, the same violation committed within 3 years of a prior violation. So a relatively small window of time in a very narrow geographic scope, as well as this language of the same violation, which suggests something more than just the same cited standard, but really the same violation occurring. That was quite different than the way that FedOSHA was applying its repeat rule, or at least the way that FedOSHA began to apply its repeat policy during the prior administration. During that administration, OSHA rewrote some of its policies on repeat violations to find and cite more repeat violations. They used to similarly require a violation at the same location, at the same establishment, but they broke down that barrier and said now a repeat violation could be based on a violation at any location within the federal OSHA jurisdiction in any other state as long as it was part of the same corporate entity. And as well as looking, rather than just looking back 3 years, which had been the FedOSHA rule, to now look back 5 years. And so FedOSHA began to pressure Cal-OSHA to adjust its policies and adjust its rules so that they could be at least as effective as FedOSHA. And so FedOSHA said to Cal-OSHA, look, if you want to maintain your approved state program status, we want to see you expand the circumstances where repeat violations can be issued. And so Cal-OSHA promulgated a new rule that was effective back in 2017 that we're finally starting to see. I shouldn't say finally. We are now starting to see more violations being characterized as repeat as a result of this changed rule. And the change did multiple things. First, it broke down that barrier like FedOSHA had done a few years earlier, where it's no longer required to be the same establishment, the same address, or even limited to a single region within Cal-OSHA, even for remote mobile crews or workplaces that move from one place to the other. Now, any violation occurring within the state, anywhere in California, can serve as the basis for a repeat violation, where any new violation may occur anywhere else in the state of California. The other change they made was that the violation must be a violation of a substantially similar regulatory requirement. Rather than the old language of the same violation, it's now focused on substantially similar regulatory requirements. And so we've seen, in the FedOSHA states, for example, FedOSHA would point to violations of a construction standard related to PPE or confined space entry or something like that, and use that as the basis for a repeat violation at a general industry location where there are substantially similar requirements, or even violations of different standards that also impose similar requirements, like guarding on one type of machine versus guarding on another type of machine. We've seen them make those kinds of leaps, which we really did not see Cal-OSHA doing historically, and now with language like FedOSHA has used for its repeat policy, the expectation is that Cal-OSHA will be making similar leaps as well. And then finally, the period of time was expanded, Cal-OSHA adopting the same new 5-year instead of 3-year look-back policy like FedOSHA had done a few years prior. And this means that a violation that was issued to one facility 4.5 years ago can now serve as the basis for a repeat violation, whereas that might have been too old and too stale to serve as the basis for a repeat some time before. So those are big changes. We are now, like I said, seeing anecdotally in our practice more repeat violations coming across the transom from Cal OSHA, and it's no doubt a result of this expanded repeat policy. And as you know, the penalties associated with repeat policies can be substantially higher than for general, non-serious, administrative, and in many instances, serious violations as well. So this is a big thing to look out for and to think about strategically how to avoid repeat violations. We do have in the archives of our Conn Carey OSHA webinar series recordings an entire program about repeat violations and strategies you can implement for how to avoid those. If you want help finding that, shoot me a note, or if you just want to talk about that, shoot me a note or give me a call, and I'd be happy to talk through some of those strategies. Now I'm going to turn it over to Megan to talk about the electronic record-keeping rule and what Cal OSHA is doing to follow on and get on board with what Fed OSHA did a couple of years ago.
Thanks, Eric. For those of you following our blog and webinar series, we have been talking about the electronic record-keeping rule for a while, and we have some significant changes at the California level to update you on. A little bit of history for those of you who don't know. Back in 2016, federal OSHA under the Obama administration adopted a new electronic record keeping and reporting requirement. It's called the Improved Tracking of Workplace Injuries and Illnesses Rule, and it's also known as the E-Recordkeeping Rule, which is what I'll call it. The rule required establishments with 250 or more workers to annually submit in an electronic portal online 300 logs, 301 incident reports, and 300A annual summaries. Though very early on it became clear that the large establishments were only going to be required to submit 300A data as Fed OSHA updated instructions on the online portal to submit only that summary data. And it left open the question about whether 301 data and 300 data would ultimately be required as well. And then the second major provision is that establishments in high hazard industries with employees between 20 and 249 must annually submit 300A annual summaries. So at this point, the 300A annual summaries is being submitted to federal OSHA through a web portal. As we transition from the Obama administration into the Trump administration, there were efforts to relax the rule, like I mentioned, on the front of whether to include additional data from the 300 logs and 301 incident reports, since those documents contain much more detailed information about the workers and the incidents and the ultimate outcomes from injuries and illnesses that the 300A data does not, that the 300A summary data does not include. At this point, all state OSH programs, including California, were required to adopt either the federal rule or a rule that was substantially identical. This opened up a rather lengthy period of time where quite a few states, California included, were not making progress in adopting a rule. Likely California was waiting to see what was going to happen at the federal level, but upon getting pressure from federal OSHA, California finally published an emergency rule in late 2018 that temporarily implemented the federal e-record-keeping rule. It was approved and it went into effect late 2018. The interesting piece about that emergency rule is that it not only required submission of 2018 300A data by March 2nd of 2019, but it also required retroactive submission of 2017 data, which was due by December 31st of 2018. So there was a very quick turnaround between the time the emergency rule was published to that initial December 31st, 2018 deadline. And of course, it still left some questions in the air because it was an emergency proposed rule, and it still needed to work. California still needed to work its way through formal rulemaking, which it's doing now. One other note that I want to mention now to put a little context on the bullet points in this next slide is that when the emergency rule in California was adopted, the legislature also passed Assembly Bill 2334, which included a couple of key provisions. One, which was specifically for California OSHA to monitor e-record keeping that was happening at the federal level. It specifically required that if California determined the federal OSHA rule that federal OSHA had either eliminated or substantially diminished the e-record keeping rule, that California was required to convene an advisory committee meeting within 120 days to evaluate how to move forward with the California version of the rule, essentially whether they needed to implement changes to protect the goals of the proposed federal rule as it was originally issued by the Obama administration. So in January of 2019 of this year, federal OSHA published an amended final rule, and lo and behold, it did not require large establishments to submit 300 and 301 level data. So whether you're a large establishment or a smaller establishment in a high industry area, you're only required to submit 300A data. Cal OSHA determined that this was a elimination or substantial diminishment of the original federal rule, and so they did schedule this advisory committee meeting earlier in the month, which we attended. It said it would accept written comments, and the goal again was to evaluate how to implement changes necessary to protect the goals of the federal rule. That comment period is open, but from what we could tell being in attendance at the meeting, the point of the meeting was to discuss what the benefits, concerns, and costs would be of requiring employers to report that more detailed level 300 and 301 data. And the concerns that we heard over and over and over again from employers and industry certainly was the privacy concern, that the information culled from these 300 and 301 forms would be much more intrusive of employees. It would include personal information. It would include information about the illnesses and injuries. It would include such information as what treatment was given, what facility the employee visited to get that treatment, what the ultimate outcomes from the injury illness were. And so we heard privacy concerns over and over again. We heard some discussion about whether this data would be available or accessible, rather either through public records requests or just provided, period. And we heard a lot of comments from industry researchers who wanted access to this data in order to have, quote unquote, better information to be able to make decisions going forward and be able to focus resources. We heard concerns about the incentives that might come about if this data was required to be submitted, that there might be an incentive to under-record or under-report. There were very few, but some comments about whether the rule was expansive enough, given how it defines establishment and high-hazard industries. There was some concern that this wouldn't be expansive enough as applied in California. And then ultimately there was a reminder from some of the people in the audience that this is all about safety and making sure that remains the ultimate goal and that can be achieved by using the 300A data, and people on the other side of the argument were saying that they wanted the 300 and 301 data in order to advance that goal. Where we are now is that advisory meeting took place on a Thursday, and one of the interesting comments was made over and over and over again that So comments being made were made in somewhat of a vacuum because the proposed rule hadn't been issued yet. And the committee did not give any indication of when the proposed rule might be issued, but the very next day it issued the rule. And the rule does not require submission of 300 and 301 data, which suggests that the only reason they were having that meeting is because they were statutorily required by this new legislation to have that meeting. But in theory, that comment period for that May 9th meeting remains open for a couple of more days. And so there's an opportunity to continue to submit comments there. And now there's also an opportunity to submit comments on the proposed rule, which we are planning on doing. So the proposed rule, it doesn't require submission of 300 and 301 data, and there's a couple of small points clarifying the legislative language so that it's clear employees have to be informed of the right to report, and they have to be provided access to injury and illness records. And there's also some cleanup that the legislature has done to make more consistent references to standard industry codes, from standard industry codes to the North American industry classification codes. This makes California regulations more consistent with one another and makes California regulations more consistent with OSHA, federal OSHA regulations. So the comments are due by June 27th of 2019. There's a meeting happening on that day, which will be in attendance as well. And the next submission date for data is March 2nd, 2020. So we do have a little bit of time on this, and California OSHA has a little bit of time to marinate with all the comments and decide what it's going to do next. So we're taking the opportunity to submit our comments, which focus on the point that we believe very strongly that the 300 and 301 data is unnecessary. For the negligible enforcement benefit that it might provide, it's going to be a huge burden to collect and report that data, because on the federal level, which is how California data is being submitted currently, at the federal level, that 300 and 301 data is not being collected. So California essentially has to create its own system for submitting that information. And as a foreshadow to this issue, there were many people who commented at the advisory committee meeting that this would be a significant financial burden and not something that they could do quickly either. The 300 and 301 data collection will certainly divert agency resources around from improving worker safety, which is the ultimate goal of the E-Recordkeeping rule in the first place. We will reiterate the privacy concerns that I discussed that were raised during the advisory committee meeting, given the increased level of information available on that 301 and 300 forms. And another big point is that the information on the 300A forms is useful information. There's information there that the federal OSHA, that California OSHA, and that industry, that employers can use to focus their resources and improve safety. The remaining comments that we're planning on making is a specific request to commit not to publishing the 300A data. Back when the federal e-record-keeping rule was first promulgated, there was a lot of talk from the Obama administration how important it was to not only collect this data from employers but also publish it. The idea being that publicly shaming employers would result in improved workplace safety. And since that did not ultimately make it into the rule, and it was very clear that from the Trump administration that publishing the data was not going to be part of the rule, we want to make the same comment to Cal OSHA that they specifically commit to not publishing it as well. Finally, we want a clarification that the division adopts the more recent federal OSHA guidance on anti-retaliation provisions. As a little bit of background here, there were some very extreme readings of the federal rule that would prevent employers from having some post-incident incentives for reporting, some post-incident drug testing, some safety incentive programs, some reporting procedures, and there's concern that if the rule was read in a similarly extreme fashion in California, that it would prevent employers from implementing some of those procedures. So we want some clarification that that would not be done on the California level either. I had mentioned that around the time the California emergency rule was adopted, that there was legislation for California specifically to monitor what was happening at the federal level. Another piece of that legislation was an interesting little extension of the statute of limitations. So in California, the statute of limitations for record-keeping violations is 5 years and 6 months. As some additional background, basically from the birth of OSHA until 2012, record-keeping violations could be enforced up to 5 years and 6 months from when you were required to make the record. In 2012, there was a D.C. Circuit decision that ruled that was incorrect. The statute of limitations was actually 6 months from when the injury needed to be recorded. So at this point, the difference between 5+ years and 6 months is significant, and it became much more difficult for OSHA to cite record-keeping violations. At this point, the Obama administration issued what became known as the Volks Rule, reverting back to the longer statute of limitations. And as this kind of tennis match volley back and forth, the Trump administration with the Republican Congress repealed that rule, that Volks Rule that the Obama administration brought into existence. And they did it by using a rarely used Congressional Review Act. And what this basically means is that the only way at this point to undo that change would be for Congress to specifically legislate a change. So at the federal level, there's a 6-month statute of limitations, and California, in response to that, reverted back to the 5+ year statute of limitations. So the takeaway here is that record-keeping violations is something to pay particular attention to in California, as opposed to, we believe, everywhere else in the country, where it's a relatively minor regulatory risk in the grand scheme of things.
Yeah, for a frame of reference, between the time of the D.C. Circuit's decision in the Volks Rule and the promulgation, the D.C. Circuit's ruling in the Volks case, and the time when the Obama administration promulgated the Volks Rule, record-keeping violations in OSHA dropped by 75%. So it showed how difficult it was for OSHA to find and cite record-keeping violations when they had that strict 6-month statute of limitations. California now, I'm fairly confident, is the only state in the country that operates under that 5-year, really 5.5-year statute of limitations for record-keeping violations, which makes it unique and a lot more risk for employers in California than in OSHA states, especially now that you may be submitting your injury and illness record-keeping data to OSHA proactively under the E-Recordkeeping rule. They're getting the data proactively, and they've got this, 5.5-year statute of limitations. So really interesting situation for California employers. And then that takes us to the workplace violence prevention rule, or rules, as it were, and I'm going to cover that one. If you've joined our webinar series the last couple of years, you know that we've talked about in the recent past a relatively new rule covering workplace violence prevention in the healthcare industry, and now that may be moving to a broader audience. But as a little bit of context, why is this important? Why is California now investing in multiple rules addressing workplace violence? Well, this is the primary reason, that there are approximately, the last couple of years, approximately 375 workplace fatalities in the state of California. About 20% of those, 1 in every 5 workplace fatality in California in those years, was the result of workplace violence, intentional acts of assault against an employee by a variety of different culprits. But 20% is among the highest causes of workplace fatalities in the state, and that is why California, and really why OSHA as well, have focused a lot of attention and resources on addressing the risk of workplace violence. There are a couple of industries where the risk is pervasive and sort of thought to be more recognized and understood to be present. One of them is in the healthcare industry. In healthcare, where you've got nurses and doctors and other staff who are generally at risk of violent acts by patients, particularly in the mental health care setting, where patients may engage in violent conduct towards the hospital staff. That is an area where there are many reported incidents, many reported very serious incidents. And so back in 2017, California promulgated its workplace violence prevention rule in healthcare. And that rule applied to home health care, emergency medical services and transport, drug treatment programs, and health facilities, which is a very broad sort of catch-all for essentially all health-related workplaces. And so that rule has been in effect now for about 2 years. Well, actually, it became in effect in April 2018, so really about a year under the new workplace violence in healthcare rule. And here's what it required. It required you to establish a workplace violence prevention plan, not unlike the I-2P2 requirements in California, but focused specifically on the workplace violence risk. And that was about looking for identifying risk factors, whether they were individual, personal risk factors, environmental risk factors, and addressing those risk factors for workplace violence with things like engineering controls, administrative controls, security systems, security personnel, alarms, panic buttons, et cetera, but it also included various other elements like coordinating with employees and unions if it's an organized workforce, coordinating with local law enforcement, coordinating with other employers who might also be present at a multi-employer healthcare facility, developing procedures to receive and accept reports of workplace violence from employees, and then training, a heavy dose of training of your workforce in things like identifying risk factors for workplace violence, identifying circumstances where there is an escalating risk of workplace violence and how to de-escalate that or how to evacuate from that situation. So this is what's been in place for about a year now, and as California has done and is currently doing in other settings, they've identified something. I suppose the agency perceives it as a successful rulemaking and a successful rule, and now they are considering expanding it to a broader set of employers. So we are now in the process, or watching OSHA engage in the process of a rulemaking to expand workplace violence prevention to general industry. So not just healthcare employers, but all employers in the general industry category. And we'll talk about on the next slide who that covers, but here it talks about what would be required if the proposed rule was promulgated as it is currently proposed. It is almost entirely identical to the healthcare workplace violence prevention rule. It is about developing a plan and having the plan being developed in consultation with employees and unions, coordinating your efforts with other employers on a multi-employer site, setting up procedures to facilitate employees providing notice about workplace violence incidents, and setting in place a mechanism for employers to respond to those reports of workplace violence. A lot of focus on post-incident and post-report conduct that will be required in your workplace violence prevention plan, meaning investigation requirements and developing responses to notices and incidents that occur. Similarly, a hazard assessment requirement, so identifying unique workplace violence hazards in your workplace in your setting and developing strategies to address them. So again, it's like taking your very generic IIPP and applying it to the specific hazard of workplace violence. And the idea of who would be covered is it's essentially everybody. It's everyone will be covered. Everyone in general industry will be covered by this rule. So presumably that excludes, some of the other specific buckets of portfolios of standards. But if you're general industry, you're covered unless you are already covered by the healthcare rule, which means you're still covered by this. You're just covered by the industry-specific version of it in healthcare. And then various other entities that are basically state-run prison systems, the Department of Corrections and Rehabilitation, and some other specific healthcare-related entities that are scheduled to close by 2021. So this would include, as well as certain law enforcement agencies. So all private employers, unless they're in healthcare, would be covered by this rule that is in the works. And then for healthcare private employers, they're already covered under that specific standard. The rest of these exceptions are for those that are not in that are California employers, meaning the state of California is the employer in these unique settings. So we'll be tracking this, and you should as well, to find out when this rule will be coming to you, and if there are ultimately some nuances to how it applies in general industry as compared to how it is currently applying in the healthcare setting. So heat illness, Andrew's going to talk about this and how Cal OSHA may be expanding this rule as well.
Thank you, Eric. For the remainder of the webinar, we're going to cover 2 items of rulemaking, beginning with first, indoor heat illness prevention. And as most of you know, there is an outdoor heat illness program in California that's quite rigorous. And presently it was SB 1167. It's memorialized in Section 3395 of the Cal OSH regs, and the existing rule applies to all outdoor places of employment and also concerns additional high heat requirements for specific industries and others where you have that high heat circumstance. And it also, specifically the outdoor heat illness regulation requires that employers adopt a written procedures, and that it requires that both employees and supervisors be trained on heat illness prevention, and that there be enough water, whether it be plumbed or otherwise, provided in quantities of at least 1 quart per employee per minute, and also requires access to shade where the temperature exceeds 80 degrees. And there is a requirement that employees be encouraged to take cool-down recovery breaks in the shade as necessary for at least 5 minutes. And so those are just the very general requirements for outdoor workplaces. But now Cal OSHA is working to develop an indoor heat illness standard, and that is based on a directive of our former Governor Brown back in 2016. And since then, there's been several discussion drafts on indoor heat illness prevention, and there's been advisory meetings, and the last draft issued on April 22nd, 2019. According to Cal OSHA, there's no anticipated further drafts. So I was going to walk through with you just key aspects of the latest draft of this rule. And one important point is there have been decisions by the Cal OSH board where they have regulated essentially indoor heat situations outside of a formal rule. It's been done under the Injury and Illness Prevention Program standard. But what this rule would do is very significantly provide concrete requirements for indoor workplaces where you can have high heat. And so specifically, what is high heat? There's a different standard under the outdoor heat illness rule as opposed to the proposed indoor rule. And for indoor workplaces, it's anywhere the indoor temperature reaches 82 degrees. And what the rule, the proposed rule provides is that you have to have the heat and illness prevention plan in writing. That can be part of your injury and illness prevention program document or a separate document. You have to have a method for identifying high heat hazards. You have to provide adequate water and cool down areas indoors where the temperature is less than 82 degrees. There's also a requirement for first aid and emergency response provisions. There's also a requirement for acclimatization to monitor newly assigned employees or when there's a heat wave. And then there's a variety of kind of rather detailed requirements concerning exposure limits, both recording those limits and also implementing control measures, whether that be administrative or engineering controls. And then there's employee training requirements like there is with the outdoor heat and illness standard and record-keeping requirements. So wanted to walk through with you some of the areas of consternation. One is, what is an indoor workplace? This is tricky. You can have employees going in and outdoors. You can have them in their vehicles. Indoor is defined under this proposed rule as a space that is under a ceiling or overhead covering that restricts airflow and is enclosed along its entire perimeter, whether that be by windows, walls, etc., that restricts airflow. And so the question that comes to mind is, when you talk about restricting airflow, are you talking about partially restricting or fully restricting? One interpretation could certainly be that a partial restriction of airflow would make it an indoor workplace. It's important to note that where it's found not to be an indoor workplace, then you would be subject to the outdoor heat illness rule, so you wouldn't be necessarily spared there. And then another issue is managing transitions from indoor to outdoor. You may have employees that are outside. They could be working in agriculture, then they get into a truck, and then they go indoors. And you could have different regulations applying whether they're considered to be outdoors or in an indoor space. And how would you manage those? So one example here is that if the outside temperature is 95 degrees, you are subject to the heat illness or the high heat procedures under the outdoor heat illness prevention standard. And those standards or those requirements are clearly delineated. However, if you get to be indoors and the temperature is 87 degrees, then you would have a whole different set of high heat procedures, and it's much less delineated under the indoor heat illness prevention standard. And then there's also a question about how you calculate the temperature. The 82 degree threshold triggering the indoor heat illness standard as proposed is 82, and it's a dry heat, it's a dry bulb temperature reading, meaning that it doesn't consider humidity or radiant heat. The indoor standard also does address work clothing. It does address specifically as a control measure to provide garments that would reduce heat, such as water-cooled garments or air-cooled garments. And that's in addition to other measures, but the garments could be provided where engineering controls are not sufficient. And then another consideration is just simply determining when an employer is required to assess and implement control measures. And this applies specifically in the high heat scenario, and that there's two different options. So this high heat scenario where you have to assess and implement control measures, that occurs when the temperature or heat index reaches 87 degrees, or where the temperature reaches 82 degrees and the employees wear clothing that restricts heat removal, or they work in high radiant heat work areas. And so when you meet one of those two triggers based on the heat and the circumstances, then you have to do one of two things. You you can measure the temperature and evaluate the environmental risk factors, or you use control measures such as engineering controls or administrative controls. And engineering control could be modifying the work area, could involve air conditioning. Administrative controls may involve adjusting work schedules or other procedures. And so we'll see what happens with this regulation. It looks like we're close to the end here, and that the standard will issue soon, potentially with no changes to the rule. But I wanted to segue to the new wildfire smoke regulation that's being proposed. And this is one of the other very recent developments, as Eric alluded to earlier. And we just learned of the new proposed rule in the last week. And so I wanted to discuss the genesis of this proposed rule, and then walk through the basic components of the rule as we are still digesting it. So essentially, the unions petitioned for an emergency regulatory protection for outdoor workers that are exposed to wildfire smoke. And so there was this petition to the OSH Standards Board, and the Standards Board granted the request or the petition and instructed OSHA, the division, to draft an emergency rulemaking provision, a proposal, that it could then consider at its July 2019 meeting that's coming up. And so the request was made back in March, and then on May 21st, just a week ago, a draft rule did issue. And so the plan is that there will be an advisory committee to develop the permanent regulation that will specifically address the hazards associated with working in wildfire smoke. So this rule applies to outdoor places of employment. And so the rule does make clear that it does not apply to enclosed buildings or structures in which air is filtered by a mechanical ventilation system, and where you can ensure that there's minimal entry of contaminants from outside. This rule also, or the draft rule, does not apply to vehicles in which the air is filtered. And of course, there is an exception for firefighters engaged in wildland firefighting. And so the basic components of this draft rule is that these various different requirements kick in when the air quality index is greater than 150 PM 2.5, which involves the solid particles and liquid droplets suspended in the air. It's one of the measures for air quality. And so that's typically where you may have the kind of air board would identify the air quality as being unhealthy, very unhealthy, or hazardous. And in that scenario where it's triggered, there would be a requirement for the employer to identify harmful exposure and to institute engineering and administrative controls. And so the administrative controls would be to require employees to remain indoors, and the engineering controls would be to keep the indoor area clean, which could be done through the filtering the air. There's also a consideration of avoiding outdoor work activities. There's requirements to communicate with employees about the hazard, and also to provide employees respirators, N95 masks, for voluntary use. And looking at the regulation, there are a couple considerations. One is that there is a Appendix B that has been offered by Cal OSHA in the draft rule. That is an informational sheet that you will be required to provide employees, and that sheet identifies some of the health risks associated with wildfire smoke. Also identifies the employer's communication system for alerting employees when air quality is harmful. Also provides the employer's methods to protect employees in that situation, and other relevant information specifically around the use of the mask, and to make sure that the respirator is properly used. And this rule is still developing. It's very likely there'll be changes to the draft language over time, and we'll certainly keep you posted. And so there are, aside from all the draft rules we've covered today, there is also a rule on marijuana cultivation that's being drafted. And we'll certainly keep you apprised as we do through our blogging of these developments.
All right. Well, that's the end of today's program. We want to encourage everybody, if you're not already registered for the balance of the 2019 OSHA webinar series, you can't beat the price. They're all free, so sign up and join us for the webinars throughout the summer, the fall, and the winter of 2019. We've got a list here of the programs we have coming up. Also, would encourage everybody to check out our blog, the OSHA Defense Report, www.oshadefensereport.com. We work very hard to keep it fresh with new content and keeping up with developments at the Fed OSHA and Cal OSHA level, and would love to know that people are out there reading it. And then anybody out there in the process safety industries, chemical manufacturing, petroleum refining, or if you've got ammonia refrigeration and you're covered by the PSM standard or EPA's RMP rule, I invite you all to join us in October in Washington, D.C. for the second annual Process Safety Summit in Washington, D.C. We had an incredible program last year with senior government officials from OSHA, EPA, the Chemical Safety Board, and other agencies involved in those industries, talking about developments in those spaces, and then with some really great breakout sessions with industry folks to share best practices and ideas like that. So if this is in your area, please do check that out. It's going to be a great program. I think we've been addressing questions as they come in today in the chat area. I think we've addressed all of them, but if we've missed anything, let us know. And of course, don't hesitate to reach out by email or phone to any of us. We love talking about this sort of stuff and would love to hear from you. And I think we actually got this done in less than an hour and 15 minutes today, rather than one of the featured films that we do from time to time. So thank you, everybody, for joining us and for what I know from my perspective was a real interesting discussion about Cal OSHA issues. We'd love to be a resource for you, so don't ever hesitate to reach out. Thanks so much.